You want me to send you the case? Or just sign? Thank you. Here. 315 Georgia 728. Yes.
No, sorry. Hard to find good help these days, huh?
Help that won't run out on you. Help that won't run out on you. Quick question. Captain Williams. It just depends on how much we got left, okay? But yeah, we might be able to do that. All right, Mr. Shart, you ready, sir?
Yes, sir.
All right.
Ready for me?
Yes, sir.
All right, excellent. Thank you, Your Honor. May it please the court. So, full disclosure, I used to listen to hip hop. Most of the rappers I used to listen to have gray hair and arthritis now, but I don't listen to current hip hop. I think that if you listen to a lot of the current hip hop, rap music out there, you're going to find that the lyrics discussed here today do not particularly stand out in this music genre. While I don't listen to rap music, I do, through my profession, know rappers. As part of my job, I watch their music videos. I also converse with them in real life. I see the difference between the persona who's talking about ops and choppers and sticks and shooting and killing, and the people who have done none of the above. The reality, Your Honor, is this music form, sadly, is about giving the streets and people that aren't on the streets, that have a great amount of consumer power, what they want to hear. It's about selling fantasy. And more importantly, for some of these young men that are entangled in this litigation that we're here for today, it's also about giving music executives, giving business people, giving people in suits what they want to hear, what they think that they can sell to the public. The only people that put themselves in danger, in jeopardy, because of arguments like the state is making, are these artists. And that's unfortunate. My client, since we're proffering, was not signed to a record label, but he wanted to be. He grew up in poverty in Atlanta, in some of the worst sections of town, and like many people, he saw his way out. And he would spend his money on studio time, trying to get better and better, and he went by the moniker SB. The first performance that was referred to by the state was performed by SB. It is not going to win any awards for production value. It is low budget, but it was his attempt to get himself closer to a dream. Just like I made attempts to go to college, I made attempts to go to law school, and we all did. This was his attempt to get closer to his dream. And what do you need to do? You need to give the streets what they want to hear. You need to give the executives what they want to hear. So you talk about things that may not be factually true. So the state, in their presentation, preemptively accused the defense of asking Your Honor to create some sort of judicial exception for rap lyrics. That's not accurate. There are specific statutes under the Georgia Evidence Code that dictate and demand that these lyrics are excluded. Among them are 404A and 403. The
Which
state
404? You said 404A?
404A, bad character evidence, shall be excluded.
But doesn't our plethora of gang appellate case law indicate that it doesn't run afoul of the 404A?
And that is the ultimate irony of the state's argument, is that they simultaneously accuse us of asking the judge to create laws and then cite judicial opinions and ignore the legislative rules of evidence that are in place. Now, yes, under certain circumstances, the state has cited to cases which allow admission of rap lyrics under certain circumstances, not carte blanche.
That's true.
And what, in their argument, they're conveniently packaging a group of lyrics, almost like it's just a combo platter. You just get them all, and saying they're admissible because of these cases. That's just not true. They need to go through each and every one of these lyrics and say why they are admissible. Why do they not run afoul of 404A? Why are they not bad character evidence? Why do they not run afoul of 401, 402, and 403? And they've attempted to do so in a couple different ways. They've attempted to do so by arguing things are admissions. To be an admission, Your Honor, the statement cannot be general.
Which evidence code are you talking about? Which one?
Well, the state's argument was that these are admissions. Okay?
So which part of the evidence code are you talking about?
Well, I'm talking about the law on admissions.
Okay, which one is that? 24-what?
I can get you the statute if you want, but...
I'm asking you. You're arguing to me.
Okay. 801. Admissions. 24
There's subpart.
8. No, 801. Well,
Subpart you want to
D.
rely upon?
I think they're going by D1. If we're going to test my memory and my ability to recite every single part of the Georgia Evidence Code, D1. So, to be an admission, Your Honor, clearly, under common sense, there would have to be some factual relationship between what is trying to be proven and what is said. Broad generalities do not suffice. Broad generalities do not have relevance. They don't have probative value. They don't have any of that. For instance, if I decide to make mixtape 1 and say, I'm a bad guy, I'm a bad man, well, and then they charge him with murder. Well, he said he's a bad man, so he must have done it. It's clear. He put it on wax. No, that's too broad. That's too broad. So you just can't say someone said some generalized thing and therefore it's admissible in a specific case. So that's the problem with the argument for admissions, because...
Sorry, wouldn't it depend upon context?
It absolutely would, and I'm going to get to the context of my client's statements because they have nothing to do with what he's accused of.
All right.
Okay? They also try to argue actus reus and mens rea about the state of mind. Just think about that argument. Their state of mind. So, we talked about Mr. Kendrick, about him recording a song in 2013. So his state of mind in 2013 is admissible for crimes committed years later. Everyone's state of mind changes instantly in this world, except rappers, I guess. They just are stuck in a perpetual state of mind that is static. The state of mind is when you commit the offense. Not years before, not years after.
Not necessarily.
Well, Your Honor, I think that the state has a hill to climb to say that somehow rappers are different than every other individual who changes their state of mind.
Well, not necessarily. I mean, to the example of you could listen to a song and it may move you to do other things. So, and that you might be listening to that song over the course of time and then do other things. So,
Right.
But anyways.
And, Your Honor, and then, of course, I think they've backed off of this, but the 418, of course, there needs to be criminal gang activity. Criminal gang activity is defined in the statute. Rapping is not criminal gang activity.
I don't think they're covering that right now. I think they're just covering the lyrical aspect under, and whether or not it covers it's to be considered under the First Amendment. So that's a separate issue. I'm not really dealing with that at this point in time.
So I don't know specifically what as it applies to my client who was just trying to make it in the rap world and decided to record some rap lyrics in 2019 is what the state said. But I don't know if this is supposed to be considered admission or mens rea. I'm not sure. That's a little unclear. But what he allegedly said, I just beat a murder rap, paid my lawyer $30 for that. First of all, I was not his lawyer. Secondly, he did not beat a murder rap. He was wrongfully arrested in 2015 for the murder of Donovan Thomas based on the testimony of an individual who lied about his name to the police while giving my client's name. He was arrested with 3 other people. The state dismissed charges against 3 other people and now say those 3 other people are wholly innocent.
Well, Mr. Farley's still a co-defendant.
Mr. Farley's not charged in that murder, and he never was. But they dismissed the charges against the 3 other people that he was arrested with and realized they had no case against Mr. Stillwell either, which was the subject of my motion for speedy trial, constitutional speedy trial. So he was released on bond. He didn't beat the murder rap. He was wrongfully arrested and released on bond, and they admitted that they completely arrested the wrong people.
State's saying that particular admission is relevant for the following purposes: actus reus to show enterprise and gang affiliation, and then under the mens rea prong, state of mind, intent, motive, or knowledge. He
didn't say I killed someone and got away with it. He said he beat a murder rap. Paid my lawyer $30 for that.
They're saying that as it pertains to your client, it's a party admission.
So Your Honor, so I guess if I'm wrongfully arrested for a crime and then I write a book about it, I'm somehow admitting to committing that crime? That makes no sense.
Well, if you write a book about it and tell on people, tell on yourself.
He didn't do any of that.
State comes back and says, oh, by the way, he wrote a book about it, and we're going to introduce it against him. And we're going to let a jury decide whether or not it's a confession.
And if he said, I beat a murder rap that I did with Johnny, Steve, and Billy, then I would tend to agree with you, Your Honor. He said, I beat a murder rap, paid a lawyer for $30. That means he went to court, he got released. How that is an admission is beyond me. He's telling that he went to court.
Well, I mean, it's context as well, and it may be relevant to and I think that's for a jury's consideration. The threshold issue is whether or not whether or not it meets either actus reus or mens rea, and under 24-4-401, it's logically relevant to some particular offense or element.
And
so,
it's not logically. It's It's
okay,
distasteful. I think.
Okay,
that
okay. We're gonna have to. Okay, that's your opinion, and you're entitled to it. Okay.
Your Honor, going to court has nothing to do with committing a crime. Being falsely accused of a crime has nothing to do with committing a crime. He's merely saying he went to court, he's been released, he paid a lawyer for that. Now, again, I'm not going to ignore the fact that jurors might find this distasteful.
Because remember, as well, it's relevant to also to show or potentially in count one. So
YSL has a history of being released on crimes that the state doesn't have any evidence of them committing.
The state's going to make their argument whether or not a jury will buy that particular argument is totally up to them. Remember, they sift and weight the evidence. I give them the law that they'll apply the evidence as they determine it to be, and then they render a decision. And so we'll have to kind of wait on that.
Your Honor, I appreciate that, but you are a very important person in this process too. And I know I don't need to remind you of that, and I give you the utmost deference in that respect. You are the one that has to determine what the jury hears and doesn't hear. And putting a lyric that I wholly admit, if Mr. Stillwell said, Max, I got to consult you before I rap about this, I would say, hey man, that's a little distasteful.
But
people might not like that.
Distasteful is one thing, but rapping about something that might be a statement against interest, an admission, a confession, or some other thing that might get you cross purposes with a prosecution for a crime that may or may not have occurred, well, that's another thing.
Your Honor, I just beat a murder rap is in no way an admission. It's in no way a confession to any crime. That's my whole point.
But it might be a declaration against interest, and
it's in no way a declaration against
it might be a party
interest.
admission on behalf of your client.
Saying you went to court.
Okay, you said that 3 times now.
Okay.
So is there any other additional argument as to that?
Well, and then, Your Honor, the state also added that they wanted to bring in other things that my client allegedly said, and this goes back into what Mr. Weinstein was saying about his client and the timing. They say they want to use, I keep a stick, ain't no avoiding no smoke on that slime that they always talk about. And they said, well, the stick, that's relevant. He's in this video with Mr. Comarvius Nichols, and in 2022, he's accused of committing a murder of Mr. Shamal Drinks with Mr. Nichols as well as Mr. Farley and Mr. Garlington. This as an admission has the same problem that Mr. Weinstein was talking about with Mr. Kendrick. This was recorded in 2009. My client is constrained by the laws of time like the rest of us. He cannot confess in 2019 for an alleged crime that was committed in 2022. That is an impossibility. To say that his mens rea is the same for 3 consecutive years is to truly treat the aspiring rapper SB.
So when did he make this song?
The state in their recitation of facts said 2019. I take them at their word.
Okay.
And I don't believe that to be false.
When did this particular incident occur?
March 14th of 2022.
Okay. All right.
So that would be.
That was the homicide, the
2 to 3 years.
purported homicide of
Shamal Drinks.
Shamal Drinks.
So again, to say that it's clearly not an admission. And to say it's his mens rea that's just static for 3 years because he's a rapper, I find is singling out. I'm very hesitant to just make these broad proclamations that rap music is singled out. But if we are treating rappers who are actually performing under stage names, if we're pretending that they are different than the rest of us humans and they have the same mens rea for 3 years and it never changes and we can always hold them to that, to things that we thought they were thinking several years before, and apply that to a crime 3 years later, I think we are treating them different. And for those reasons, Your Honor, I believe that those are the only lyrics that directly affect my client. I do believe that, the state, I will yield to Mr. Steele to ably argue on behalf of his client, but I would ask that you rule that those lyrics that I discussed as performed by SB in 2019 as inadmissible. Thank you, Your Honor.
Thank you, sir. All right.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it, just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it, just smash it. Hit that like for deal with Christian.